Hey everyone, welcome back. My name is Dasso Pardalis, and this is another PN Lawyers Facebook Friday Live. Last week we spoke about family court issues surrounding domestic violence and child custody. And so this week, I think we'll go a little deeper into the court system and discuss the first steps in the arrest and criminal court process. Basically, the arrest, the processing, and the arraignment, okay? So typically in New York, this process begins when an individual is arrested as a result of a police officer observing a crime or receiving a third-party complaint. The individual is taken to the precinct where arrestees are placed in holding cells while the police process paperwork. So arrest processing at the police station typically involves taking individuals' fingerprints and pedigree information. These days, this is often done electronically. However, in some precincts, or when the machine is down, it is still also done the traditional way with ink. So they'll roll the finger in ink. The arresting officer will then run the arrestee. What that means is the officer will check databases for any outstanding arrests, prior arrests, bench warrants, NCIC notices. NCIC stands for National Crime Information Center. So basically they're looking for notices from the FBI, from federal agencies, multi-state warrants, things that take place out of New York that might pop up that they can hold the person for. They'll even look for vehicle and traffic law offenses here in New York, or if any I-cards have been issued. What is an I-card? An I-card is an investigation card. It's basically a note on an individual that is being sought for questioning or is being investigated or suspected of a crime. So if you haven't been arrested or if they're not looking to arrest you, a police officer can issue an I-card on you so that if another officer picks you up somewhere, that officer will be informed and he can come question you or investigate what he was looking for the person for in the first place. This is not not procedural here, but I want to give you all some good legal advice, okay? Keep your mouths shut. Do not make any statements regarding your case. You are not going to prove or disprove anything to the officer, okay? You have the right not to speak. Use it, okay? Again, do not, under any circumstances, make any statements. The police are allowed to lie to you. They will tell you that if you admit or disclose something, you will be free to go. They are allowed to make up stories. They're allowed to trick you. The only thing that anyone arrested or held by the police should ever say is, "I want my lawyer." All right, back to the process. So now once all of this is done at the precinct, typically 1 to 3 hours, unless the police are holding someone for a cool-off period. Cool-off period, is exactly what it sounds like. It's maybe they're holding you to either sober up or to calm down if you're overly aggressive. But the typical process at the precinct takes about 1 to 3 or 1 to 4 hours for processing. Once that's done at the precinct, then only one of two things can happen, okay? The arrestee is either transferred to central booking or issued a desk appearance ticket, what we call a DAT or a DAT. So let's start with the DAT, the DAT. In less serious charges, in minor offenses, the officer has the right to issue you what is called a desk appearance ticket, what we call the DAT informally, okay? This means that rather than having to wait in custody and run through central booking for the next 24 hours just to see a judge, you will get a ticket, you will be sent home, and you will be told to appear in court on a later date for the arraignment. This, guys, is the best case scenario if you or a friend has been arrested. The best case scenario is a DAT. Again, DATs are only issued in relatively minor violations, in minor misdemeanors, and in some cases in some very low-level felonies. So that's the DAT process. The other process is the one everyone kind of usually ends up going through, and that is getting sent to central booking. What is central booking? It is a very special place. Central booking is basically a giant maze of holding cells where arrestees from every precinct in New York City go to wait in line to be arraigned, to see a judge. It's not a very nice place, okay? It's not a luxury Airbnb, it's not a Hilton. So what do you do if a loved one or a friend is in central booking, or if you think someone has been arrested and they might be there? Well, look, the first and the easiest thing to do is to call a lawyer, and he or she will take care of it all. But here's what you can do if you cannot afford a lawyer or do not want to call one for some reason. You can call the criminal court arraignment clerk to try to locate your person. Sometimes you can go by the person's name and the date of birth, although it's usually not the easiest thing to do. The best way to locate someone who you think might be in central booking is to get the arrest number of that person from the precinct or from the arresting officer. Then, once you have the arrest number, you can call the arraignment clerk and ask them to look up your arrest number. In New York City, central booking, and specifically the arraignment parts, are open every day, 7 days a week, from 8 a.m. to 1 a.m. The courts are open 7 days a week. The arraignment clerk is open 7 days a week from 8 a.m. to 1 a.m. If you need the contact info for any arraignment part in New York City, you can just call or message us. And all of that information is regularly updated and located at the Legal Aid Society's website at www.legalaidnyc.org. Okay, so you're now at central booking and you're waiting for arraignments. And what are arraignments? The arraignment is the end of the arrest process and the beginning of every criminal case. So what is an arraignment? The arraignment usually happens within 24 hours of the arrest, and it's the first time you go in front of a judge after you've been arrested. So at the end of the long line of cells that we spoke about at central booking are the arraignment courtrooms. At the arraignment, you are told for the first time by the district attorney in the court what the charges are against you, okay? And you have the opportunity to answer those charges by telling the court if you are guilty or not guilty. This is called the plea. The lawyer will say, Your Honor, the defendant pleads not guilty. Once you plead not guilty, you will get a court date for a hearing or a trial, okay? At this point, the prosecution can ask for bail to be set if they believe the defendant is a flight risk. So, while the arrestee is sitting in central, waiting to be arraigned, the fingerprint scans, the processing documents, all the stuff from the precinct, they've been sent over to central booking or brought over with the person. And that information is transferred over to the Division of Criminal Justice Services up in Albany, okay, in order to create what we call a rap sheet. And what we are looking for at the arraignment is the assessment pages of that rap sheet to see whether the person is a candidate for a release when it's time for the arraignment. This document analyzes each person arrested and either recommends that they be released on their own recognizance, what we call ROR, okay, or it may recommend that they not be released, at which point the district attorney usually asks for bail because the person might be a flight risk, okay? So some of the main criteria on this recommendation for release are the following. Does the person hold steady employment, and where? Has the person lived at the same address, and for how many years? Have they lived at the same place for an extended period of time? Are they stable? Does the person have family waiting for him at the end of this process? Are there people in the courtroom waiting for this person? A wife, children, brothers, sisters, a community, right? Does the person have a prior criminal record, or what we call prior contact with the system? How extensive is that prior contact? All of these things play into whether bail will be set or not, and we want to know this as early as we can, but at a minimum we get it in the assessment right before arraignment. So if many of these criteria, and there's a lot more, okay, but those are the main ones. If many of these criteria come back negative, the DA will usually ask the judge to set bail, or in more serious offenses, the DA will ask the judge to set bail, even if they don't come back negative. What is bail? In short, bail is a pledge of money to secure that a defendant return to the court once he or she is released. So bail or no bail, once the accused has pled not guilty, then the next court date is set and the process begins. So that's the short on how the typical arrest to arraignment process goes in New York. But a lot of that has changed now with the COVID situation, and the courts have had to make some pretty serious adjustments to the way in which these proceedings have moved forward. The criminal courts have not closed. They cannot close. People are still being arrested. People are still being processed. People do still have due process rights. So the criminal courts must move. They cannot shut down. And the criminal courts are continuing to process people who are arrested every day. But things are done very differently now. What was once a crowded courtroom full of clerks and lawyers and court officers and audience members has changed in the era of social distancing. So first, the main change, the launch of video-only arraignments. Video-only arraignments are now set up in all criminal courts in the 5 boroughs. The judges, the lawyers, the court reporters, everybody can appear by video connection from anywhere. The person arrested is then brought to a camera in the court building, and the arraignment proceeds. Prior to the parties all coming together on screen for the arraignment, the defense lawyer is actually given an opportunity to speak with his or her client privately by a private video connection. And the arraignment proceeding does not take place until after the lawyer-client video meeting has taken place. So here's an example of a case that came into our office last week. A grandmother calls, and she tells us that she believes her grandson has been arrested. We get all the information that we can, where he was arrested, what time he was arrested, what we believe he may have been arrested for, where is he being held, when was the last time she or anyone spoke to him, the date of birth of the individual, his employment status, where he lives, how long has he been at that residence, the things that we know are going to be on the assessment, whether we can believe that he may be ROR'd or not, right? What is the person's marital status? Do they have children? What is the person's prior criminal history? Do they have prior contact with the court? What is their education level? Are there any health concerns? And many, many more. All the things that we discussed again that we know may play into a potential bail hearing later. We want to get that as early as possible in the process. Immediately, Carla, our resident member of the Criminal Defense Bar of Puerto Rico, and Athanasia, our office manager, both working remotely right now, make contact with the precinct. They get the name and the email of the arresting detective. They prepare a letter of representation to the detective so that we can get an arrest number, which we also discussed before, to be able to track down our client in the criminal system. They then prepare and fax, yes, fax, a notice of appearance to enable us to maintain contact with the clerk of the court. Once that notice of appearance is in, once Athanasia and Carla have sent that notice of appearance, we are then immediately provided with a link to enable a virtual private conference with the client. All of that in about a half an hour. A half an hour. Now, mind you, usually this process takes like a half a day or a full day. So a link was then immediately sent to us within minutes by email of the court acknowledging their receipt of our notice of appearance. We click on the link, and there we are. We're in the holding pen of Queen Central Booking on video, okay? And I'm looking from the outside through the bars of a cell, and there he is, my client, right? I recognized him. He had been to my office in Astoria before on a civil matter. He remembered me and said he was happy to see me. I explained to him what he was being charged with, and that within a few minutes, on this same screen, that we would see the judge. I asked him if he was okay. He said he was okay. He sat down, and during the conference with the client, the clerk sent me another link, which was for the remote courtroom. Once I had discussed everything with the client and advised the client not to say anything and that we would be speaking for him, I clicked the link, and there we were. Okay, our client was now somewhere in the hallway, in the bowels of Central Booking. He was standing. I spoke to the clerk first. The clerk thanked me for wearing a suit. He said, "You wouldn't believe what comes through their feed with respect to defense counsel's attire," which was kind of funny. And then within a minute, we got started. The client was arraigned in just about 5 minutes, and it was over. The judge was releasing him with no bail, ROR, released on his own recognizance. The client was going home. The most efficient arraignment we have ever done. So guys, that's my brief overview of the arrest and criminal arraignment process in New York City. the first steps of any incident and arrest in New York. Thank you for joining me. Let's see if we have any questions, okay? Why didn't my lawyer say anything at the arraignment about how they arrested the wrong guy and that no one read me my Miranda rights? The answer to that is nothing should be divulged at arraignment. It's not the place to argue any portion of the case. It's not the place to make any statements. All of those statements can be used and interpreted against the criminal defendant. And very often we have attorneys who go in there and start saying things that may or may not be accurate. They haven't properly investigated the case. So walking into an arraignment and saying, you know, they got the wrong guy, or they didn't do this, or that's not what happened, you know, the other person hit him first. It's not the place for it, and it could hurt your case down the road. So the best thing you do at an arraignment is you just plead not guilty and you start building your case. And if there are issues, they got the wrong guy, or they didn't read you the Miranda, or they improperly searched the glove compartment, or the breathalyzer wasn't working, that will all be flushed out as the case proceeds. But anything you say at the arraignment can be used in a grand jury indictment down the road, and you want to avoid that. So the only thing that you should really say at an arraignment is not guilty. When you're being questioned or detained or arrested, don't speak. Just keep your mouths shut. You don't have to say anything. You're not going to prove your case. You're not going to prove your innocence. And all of those statements will be used and misinterpreted and twisted, and that's permitted. So the best thing to do is just stay quiet, okay? Just stay quiet until it's time for the case to actually proceed. Did you ever handle a case where a lawyer let the client speak at the arraignment? You know, we had a case years ago where a client came to us after he had been arraigned, and he said he didn't feel comfortable because his lawyer said many things and allowed him to speak at the arraignment, and those things were misinterpreted and twisted. And this particular client was accused of a really serious offense. They were accused of marital rape, okay? And it was clear to just about everybody, even the district attorney, that was not the case. But what happened was the couple, the married couple, had a child that was sick, and the doctors came back and said a few years later that if they were to have a second child with the advance of stem cell technology, that they could plant the cure for child 1 in future child 2 and cure child 1 once child 2 was born. So the husband said, you know, obviously this is amazing, let's have child 2 so that we can cure child 1. The wife had wanted nothing to do with the husband anymore. She wanted a divorce, and she did not want to do that. So, you know, they argued about this, and the wife left the house and was advised that, you know, in order to stop him from pressuring her to have the baby, that she should, you know, report a criminal act against him. And she reported that he raped her. He was then arrested on that charge, and the criminal defense attorney that he had allowed him to speak at the arraignment. And this gentleman, his grasp of the English language was very poor. And he said, "I'm sorry I forced her," right? And what he meant was he was sorry he tried to force her to have a second kid when she didn't want to. You know, I don't think he even properly understood what he was being charged with. And that statement was then used to indict and go into a grand jury and a really deep case. And in the end, it was shown that he had no intention and did nothing of the sort, and he was found innocent. But that's the risk and the peril of speaking prior to or during your arraignment. And so, again, keep it quiet, and let the defense do their job. What are the reasons that a police officer is allowed to pull you over? For example, reasonable cause. To what is the correct protocol? Okay, so, hey Steve, I see Joe threw in a comment there, which is awesome. But police can pull you over when they have a probable cause, okay? A violation of the traffic laws is probable cause: speeding, swerving, the smell of marijuana or alcohol or some other substance, a match on a crime report can be probable cause in the area at around the same time. And even police using what Joe is writing now, that someone looks suspicious, okay? Although that's, you know, some of the weaker end of probable cause, but I mean, look, if a car is swerving up and down the road, the officer has probable cause to believe there may be a drunk driver. So, all right, take care, guys. Have a great weekend.